We are now live and on the record. Hear ye, hear ye, hear ye, all persons having anything to do before the Honorable, the Justices of the Massachusetts Appeals Court, now sitting at diverse locations within and for the Commonwealth, draw near and give your attention and you shall be heard. God save the Commonwealth of Massachusetts. Court is open.
Good morning. Welcome to the Appeals Court. I'm William Meade. With me today are Justices Wolohojian and Lemire, who will be the panel for your case. Hopefully there won't be any snafus on Zoom. Sometimes it happens. If it should happen, we will do our best to reestablish contact with you and no one will be deducted any time. Each side has 15 minutes. There'll be a clock in the upper left hand where the emblem of the court is right now. You have 15 minutes. We have read everything. You don't have to use all 15 minutes. Please be aware of when judges are trying to ask a question. It's often hard to interrupt on Zoom. With that, I'll call this case 21P636 Commonwealth versus Garofalo. Mr. Garofalo.
Good morning, Justice Meade, Justice Wolohojian, and Justice Lemire. I come before the court today where hopefully Lady Justice will be on my side with a new statute by lawmakers on Beacon Hill. I think in 2018, I had my first attempt to try to expunge this due to errors by law enforcement, and my argument wasn't clear and concise enough. But now with the police report in hand, along with the stated facts in my brief, I hope justice can come to light today and you allow my expungement. If I can cite the police report here, there's multiple discrepancies on it. One being the incident location itself, 25 Lenox Street, and in his narrative, he writes 28 Lenox Street. There are also some additional ones where he states he's going to pretty much file charges against them for attacking Miss Widrick. That was my sister, Mrs. Valvert, who's Garofalo. So with the brief and the appendix, along with the narrative, the only thing I wish I had was the 911 calls that the police calls I made, the first and second, looking to the Lawrence Police Department for help, de-escalate the situation. Unfortunately, I got an incompetent officer who responded, who did nothing the first two times. And then when came back, once other issues happened, I became, in my eyes, the victim. Well, I was the only one who got arrested, yet the other person who fled never had a follow-up or never got arrested and had any kind of...
Can I ask you a question, Mr. Garofalo? I want to clarify what's before us. Your notice of appeal was from the denial of your second motion to reconsider in last July 14th. And we don't have the appeal of the denied expungement order before. It's just the denial of the second motion to reconsider. Is that your understanding as well?
I thought on the first, so after the first petition for expungement, the appeals court allowed me to bring it back to the lowest court with more information and to re-argue my case. I believe I gave them the police report along with all the other information that they needed. And then the denial was based on receiving credible information from the officer, yet omitting my testimony and my facts that I brought in to the court.
Well, your notice of appeal, the motion to expunge was denied on March 16th.
Okay.
And then you moved to reconsider, and that was denied. I'm sorry, that was filed on April 7th, and the judge denied it on the 24th. But then you didn't do anything until the 7th of June.
Right, for the appeal, is that correct?
Yeah, but the only thing timely before us is the second motion to reconsider.
Okay, so the second motion to reconsider was denied on the ground. Hold on, I apologize. You may have it in front of you right now. I got to look for it, but I think it was based on the grounds that the officer received credible information from my mother. Is that correct? Was that the reason for the denial?
And that was because this is the second time this has been on appeal. The prior panel already said in your circumstances that the police had probable cause to arrest you based on what your mother had told them, that you had pushed her.
Right, and I understand that, but the issue.
So you have to, I mean, even if the motion to expunge was properly before us, you need to show by clear and convincing evidence that there was demonstrable error. And we've already said in the prior appeal that there was not one.
Right, in which the higher court allowed me the opportunity to bring it back to the lower court because I did not at the time during my oral argument convey to the panel that the officer was informed by both parties and the victim, Cassandra Widrick, who was my ex-wife who was beaten, that she had attacked me. So if he received probable cause to arrest myself, he also got probable cause to arrest her. And
we also, the prior panel, the prior panel addressed that as well. And they said the police had discretion as to who they were going to arrest. And an exercise of discretion isn't a demonstrable error.
They did address that, Your Honor, because I didn't even think about that at the time and I didn't argue it.
Mr. Garofalo, are you aware of any case or other legal authority that defines demonstrable error as it is used in this statute?
No, this was an uncontested law. I do know that what happened, I called the police 3 times that day. I tried doing everything in my power. And then I had an officer. I wish there was body camera back in these times, but he did nothing 3 times. There were acts of, there were crimes actually committed. The officer still didn't do anything. And then it took my wife being beaten and bloodied for him to come the 3rd time after I called 911. And in the meantime, when they were being dispatched is when my mother attacked me. And the officer knew that my mother attacked me, but he did not arrest her. All I'm seeking in the justice system is fairness. And I still have not given up in the justice system. I fought for this country, for the justice system, and I believe in it. It may not be the perfect system, but I know what happened here was multiple demonstrable errors, from him stating he was gonna seek out my sister to hold her accountable for her actions, to, I guess he didn't even write anything about my mother, but honestly, I just wish we had video, because what happened that day was a day in infamy for me. And it was the most disgusting thing a police officer could have done, was to just turn the other cheek with certain things. And I understand he was more passive and he thought at the time it was the right thing. Unfortunately, he's a human being, and what he did by doing nothing was the incorrect thing based on his training. And I don't know if I'm just arguing that correct. I wouldn't keep pursuing this because I know this is right. I know the law here, and maybe I should have got an attorney. I hired a paralegal to get limited assistance in formatting and what have you. But I know that this is not right. And I know the lawmakers who drafted this bill would agree.
Mr. Garofalo, we can consider whether or not there were other maybe things the officer could do, but when it relates to your arrest, what about your arrest? Was there an error? In other words, you're suggesting you should have arrested your sister, you should have arrested your mother, you should have done other things, they should have come sooner, they should have responded in a more appropriate way. At some point, they made an arrest of you. What is it about that particular event of your arrest that was in error?
Well, there was a couple, Your Honor, but the first immediate one was he knew that she attacked me and it was in self-defense. So hypothetically, he were to arrest me, all right, he may have had probable cause there.
All right, stop right there. If he had probable cause to arrest you, don't we end our argument there?
Yes, but what about self-defense? Why didn't he arrest my mother? Why was there not fairness in holding people accountable? So if there was an allegation that, you know, I pushed my mother, why wouldn't there be the same when I and my wife said that I was attacked by her, did he not arrest her with probable cause?
And it's your position that the, as you classify it, unfairness is what is the demonstrable error?
Well, yeah, he acted arbitrarily. I mean, I don't see how, was it because of my gender? I don't know. But why would he not arrest?
He can't be said to be operating arbitrarily if he had probable cause to arrest you.
But he also had probable cause to arrest her. It just,
Oh,
I was only
okay.
called the police these 3 times trying to do everything in my power to do the right thing. I mean, you would have acted the same way, Judge, but like, there's
But
nothing.
that's
I
why
could
I
have done
asked
better.
you, Mr. Garofalo, do you know of anything that defines the term demonstrable error? Because it's not just a mistake, or it's not just, it's not that the legislature didn't use the word mistake, or they could have done something else, or if the police, you know, should have also arrested someone else. They use the phrase demonstrable error. And are you aware of any case or other legal authority that defines that phrase?
Well, as far as any other case referring to this statute, I looked, Your Honor, I didn't see anything, but I would hope that the legal, because this is the only way I can expunge this, because I had one other thing, even though it was dropped, where if you have more than 2 on your record, you can't get this matter expunged. So this caused a lot of grief in my military career. Not that I'm in the military anymore, but just this was a wrongdoing to me that I feel needs to be rectified. And maybe I'm not going along the right way.
May I ask you a question about, as I understand it, at one point you had your records under seal?
I had them sealed, yes.
And they're no longer sealed?
I unsealed them to bring clarity to the court, because the first one, the first time I petitioned for expungement, Your Honor, it seemed very promising, but he was like, well, I can't even look into this. You know, and he didn't, from what I was told, he may not have wanted to take precedence on a new law, like, because there can be controversy there, I guess. With uncontested laws, it's better just to cite a pre-existing law. But yeah, I unsealed it, I sealed it back up, and I unsealed it again, and now here we are unsealed. I'm just going to leave it unsealed till hopefully it gets expunged, whether it's through means of demonstrable errors or by other means.
Well, I was having trouble understanding. You mentioned in your brief that your record has caused you employment problems, or you anticipate that it will cause you employment problems. And I noted that the statute with the sealing statute, the statute for getting things under seal, you know, has a provision for people who are in at least government service, so that, you know, those records can't be used again. They can't be used, I believe.
I was not aware of that. I was told when I had my FBI background check, when I went through border protection, that they did question, the special agent questioned me about it. So maybe he wasn't following the law. I don't know, but.
Well, no, I think it may have been state, but I don't know. Okay, but in any event, right now it's completely unsealed. Is that the status now?
Yes. Yes, Your Honor.
Okay, I think we understand, unless there's something else you want to tell us.
Well, I'm just hoping that, I mean, it sounds like the panel's already pretty much made up based on the appeal. But I do hope maybe you can move forward with allowing this expungement, or maybe giving me guidance on another way to get this expunged, because I feel that the officer definitely could have acted differently in every aspect. Like, I can name 5 different errors, but I guess pertaining to my arrest, if you don't admit hers, then yes, he had probable cause, but he also had probable cause to arrest other parties that he never acted on, and he completely ignored other illegal acts prior to the escalating offense that happened. But I mean, this is not fairness. This is not justice for him to just arrest me and not arrest anyone else when I was the one seeking their help. That's why I don't seek their help anymore. And it's unfortunate because I have friends through my military career that have been very competent law enforcement officers that, you know, honor the badge. But when you get a crooked one or an incompetent one, I try to handle the situation myself as a law-abiding citizen. And that's actually been very good for me.
Okay, thank you.
Thank you, Your Honor.
Ms. Johnson?
Good morning, Your Honors. May it please the court, Kayla Johnson for the Commonwealth. We are here on the denial of the defendant's motion to reconsider the denial of his second expungement petition. And as the court mentioned, this particular expungement petition was before a panel of this court before. And as in the first instance, the defendant still has not shown that there was demonstrable error by law enforcement warranting expungement in this case.
Can you help me with the definition of demonstrable error?
Yes, Your Honor. So there are not any decisions defining demonstrable error as it pertains to this statute at this point, where the statute is relatively new. There was one unpublished decision by a panel of this court that came out that addressed demonstrable error in the context of witness, demonstrable error by a civilian witness. And that is 2021 Westlaw 278355, Commonwealth v. MA. And while it's not demonstrable
Was there anything in the legislative history, if there was any legislative history?
Not that I found. It's possible, but I didn't see anything about the definition of demonstrable error. But I would argue in this case, particularly, that just because the officers didn't necessarily act in the way that the defendant hoped that they would have in this situation, that certainly does not rise to the level of demonstrable error in this case, particularly to warrant the expungement of the record in this case, where I think it's clear that there was probable cause to arrest the defendant on the night of his arrest, where there was the statement that by his mother that he had pushed her on the ground. So I think the fact that there was probable cause to arrest the defendant, and even though he's not, he believes that there are other things that the officer could have done, I think really it boils down to the fact that there was probable cause to arrest as to the defendant, and that is not demonstrable error by law enforcement. If there are no further questions, the Commonwealth can rest on its brief.
Thank you. Thank you both.
We are now live and on the record.
Welcome to the Appeals Court. I'm William Meade. With me today are Justice Wolohojian and Lemire. Will be the panel on this case. Hopefully there'll be no Zoom snafus, but if there is one, we will do our best to reestablish any connection as soon as possible, and no one will lose any of their allotted time, which is 15 minutes aside. You needn't use all of your time. We have read everything. And with that, I will call this case. It's 21P779, DEVICO versus Sullivan. Mr. Phelps.
Yes, good morning, Your Honors. My name is Attorney Jerry Phelps. I'm representing the appellants Paul and David DeVico. This, as you know by reading the briefs, this is a verified complaint in this matter alleging that the defendant, the appellee, was orally instructed by her parents to establish a trust for the benefit of all her children. Instead, the complaint alleges the defendant set up a trust with herself as the sole beneficiary. On these facts, set forth in greater detail in the verified complaint, taken as true, which the court must do on a motion to dismiss, the plaintiff's appellants have stated a prima facie case for the existence of an express oral trust. Whether these allegations of the complaint will withstand the crucible of discovery was not before the trial court. In dismissing the complaint,
The two claims, the two causes of action were, and correct me if I'm wrong, fraudulent inducement and breach of fiduciary duty?
That is correct.
All right, so what are the elements for fraudulent inducement?
The fraudulent inducement elements would, I'm going to do this off the top of my head. First of all, you have to have a person that's susceptible to being persuaded, if you will. The second is actual deception on the part of the defendant. The third, a causal relationship between the deception and the inducement.
And the harm.
Yes. and the harm.
Okay, so I read the complaint and I didn't see any allegation of any statements at all made to either of the two plaintiffs by the defendant. And so I'm having a hard time seeing how you've stated the elements of a fraudulent inducement claim on this complaint.
I would have a tendency to agree with you, Your Honor. even though
Okay,
the
so why
argument
don't we
against
then,
myself-
so then why don't we look at the breach of fiduciary duty
that-
claim?
that I
Um,
tend to
I-
be on the case.
At what point in time do you think that this complaint gives rise to an inference that the defendant became a fiduciary?
Upon the express instructions from the parents to the defendant, that would take place, that would establish an express oral trust, which then.
Okay,
would be
and
the
so
power-
let's say we accept that. That fiduciary duty would flow to the parents.
It would.
Okay, so then at what point in time, and they wouldn't have standing, I don't think, to assert a breach of fiduciary duty claim at that point in time, if we had no further facts. Let's just take that right there. Can we agree on that?
I'm not sure if I understand the question, Your Honor, with all due respect.
All right, let me try it another way. At what point in time, based on the allegations of this complaint, do you think we can say that a fiduciary duty was that the defendant became a fiduciary for these plaintiffs?
Correct. It's funny, I have not actually cited the statute in my brief, but I believe since they are beneficiaries, I think it's quite clear that if a fiduciary relationship is established, that the fiduciary would owe a fiduciary duty not only to the donors in the case of bar, but also to the respective beneficiaries. I think that's black letter law, Your Honor.
Okay, so then you think that that duty then arose as soon as the parents gave the initial instruction? Is that your view?
Yes, ma'am.
And so that was breached almost immediately?
As soon as she failed to follow the express oral instructions from the parents, yes.
All right, so then you run into your statute of limitations problem.
Correct. It's not a problem, quite frankly, because if a fiduciary duty exists, then under the discovery rule, see, the lower court implemented a reasonable prudent person rule where it's not. It's an actual knowledge rule. That's solid case law. Okay, and under the actual knowledge rule, there has to be a repudiation of the trust, which is a specific act that has to take place by the defendant in this action, and it never did. So as a result, using the word accrue doesn't even apply, because the cause of action in this case hasn't even accrued yet. I would argue that it accrued once they filed this motion to dismiss, because they're obviously repudiating any interest that they have in the trust. But up until that point in time, which is well within any statute of limitations, there's been no official repudiation which again, I emphasize is a specific act that's required under the law. And it's
Why
never
wouldn't the
taken place.
transfer into her own name or transfer into a trust that didn't include the other children as beneficiaries be the repudiation?
It just isn't what the law is, because that's a reasonable prudent man standard, or a reasonable prudent person standard, and that's not what the standard is when a fiduciary is involved.
I'm not talking about the discovery. I'm talking about the act of repudiation. What's your best case for what constitutes that the repudiation doesn't occur until they file some sort of document in court, as opposed to an act?
I'd have to refer to my brief, Your Honor. It's briefed thoroughly in my brief. I've probably dozens of cases that I've cited.
But your position is that the act of creating a deed first in her name and then in a realty trust does not constitute a repudiation.
That's correct. That's correct, Your Honor. And Marcy. Repudiation of trust doctrine, I briefed beginning on page 15 of my brief.
Am I correct? In footnote 4 of the judge's decision, the judge refers to a certificate of trustee.
Yes.
Was that attached? I didn't see that in the record. Is that in the appellate record?
Good question. I think this might be something that the appellee's attorney might have been endeavoring to put into the record, but I'm not sure. Quite frankly, I mean, I wasn't concerned with it because I don't see the relevance, to be honest with you, Your Honor.
Well, I think the lower court judge made some reference to the registry documents being public record. And I'm not sure if the judge reviewed the registry documents online or whether they were submitted, but
I think what he was, if I may, Your Honor, I think, and not to put a thought into the judge's mind, but I think what he was getting at was, all this was a part of public record, throughout the years, that, this is what the state of the title was of this piece of property. Doesn't matter. The repudiation is the key that starts the accrual period. And quite frankly, I've run into cases before where, something takes place in the interim, but, she may not have gotten around to putting in place a trust that my clients allege was supposed to be set up for the benefit of all the siblings. I mean, there's a lot. So that's why the repudiation is so important, and is detailed as a specific act under the law. It's critical, and it hasn't taken place. Now, a lot of this stuff, what's going to happen when we get going with and during the crucible of discovery, well, things can take on a whole different light, but that wasn't before the trial court in this case. And taking the allegations of the complaint as true, which the court must do on a motion to dismiss, and looked at it in the light most favorable to my client, then the case shouldn't have been dismissed. I mean, the law is on our side.
Is there anything else you wanted to tell us, Mr. Phelps?
No, I think that does it, Your Honor. I'd like to, again, I'd like to rely heavily on my brief, and I want to thank you for listening to my argument.
Okay, thank you.
Thank you,
Mr. Ryder.
Thank you, Your Honor. I obviously want to respond to any questions that the panel has. I think I'd agree with my brother, it is a well-briefed case. So I don't want to bore you with going over things that are in there. But one of the things that I did want to emphasize is the public policy aspect of this. There's a reason why we have statutes of limitation. The reason why we have statute of limitations is so that claims are brought while evidence is still fresh, while witnesses are still alive in this case, while memories are still fairly fresh. What happened here was a deed was recorded at the Registry of Deeds running from the parents to my client, ANNMARIE Sullivan, in 2006. She then flipped it over into a nominee trust for herself. It's not a real trust. It's as I quote in my brief, it's not a real trust. It's a nominee.
Well, let me ask you about that.
Yes.
So if I were a brother and I was just checking on things and I see the deed go to her and then into the I'm probably mispronouncing the last name, Davico Family Trust. Wasn't the nominee trust named after the Davico family?
Well, it did say Davico Realty Trust was the name. That's correct, Judge.
Then I'm assuming my sister's done all the right things at that point.
Well, you might if you looked at it the day after the transfer, but they waited 16 years or 13 years.
Let's assume they waited till after let's assume they looked at it at any time between the time they filed this suit and there's a nominee trust in the name of the family. It's not in Sullivan's name. Her name is now Sullivan. It's in
Correct.
the Realty Trust. Obviously, there's no schedule of beneficiaries filed or recorded. It's on presumably on record in some law office, which has not been discovered as of yet. So isn't that some fraudulent act that covers up, gives an appearance of a trust when there was not in effect the wishes of the parents? Right?
I'm sorry, Judge. I realize we're at the pleading stage, so that's not pled in the complaint as an element of the fraud. What they're trying to say is the element of the fraud was the mere transfer.
No, but I think Judge Lemire's question goes to why isn't that part of the statute of limitations argument if there's fraudulent concealment? There's active concealment. I guess I would ask you the question another way, is what was there in the public record, which no one has put in the record here for us? What is it that's in the public record that would have disclosed the beneficiaries of the nominee trust the defendant created?
There's nothing in the public record.
Okay, so that seems to me to answer Judge Lemire's question about how could these brothers have discovered that at least on the pleading, if we take the pleadings as true, that they couldn't have known from the public record that the sister had not carried out what the complaint alleges were the parents' wishes.
Not by going to the Registry of Deeds.
Okay.
That's correct. They had to take, I'm sorry.
So then that takes me to footnote 5, which in the judge's decision, which I believe this decision occurred before my opinion in re collegia, but there is no obligation to have provided. This is a trust that would have been created before the enactment of the Uniform Trust Code. There would have been no obligation on the trustee to make annual disclosures to the beneficiaries until the beneficiaries' interest became ripe, sort of sprang into being, which would have been upon the death of their parents. So that would have been, as far as I can tell, 2015, 2012. And even,
2012 and 2015, correct.
and even then, the sister did not provide provide the disclosures. So again, how does this help? How does this footnote help the judge's analysis? Because not receiving anything, how would that have helped them learn? Can you explain this footnote to me? The logic of it, both the law in it, it doesn't seem accurate to me, and the logic of it seems opaque.
I have to agree with you, Honor. I think probably Judge Gildea didn't know that the creation of this in 2006 would have predated this.
Okay,
but it
so
is. But
if there's a reasonable, if you're entitled to some kind of discovery rule whereby the date of accrual is determined by when the plaintiffs knew or should have known that they had a cause of action. Can you tell us when you think that date is, and on this record, how is that date established?
Well, I would say at the latest, Your Honor, it was on the death of the father's death, which was on February 21, 2012, and which is in the supplemental appendix, if I can.
Why wouldn't it be the mother's death in 2015?
Well, no, I would think that that the father's death would give rise to at least a duty to make some inquiry. Now, if they had made some inquiry at that time as to, where do we stand with this trust? You're living in the house. Where do we stand with this trust? When are we going to get? How come we don't get any kind of tax reporting forms for this trust? How come we haven't heard anything about it? I would suggest, Your Honor, that a reasonable time to trigger that would be on the father's death, when people are thinking about.
While the mother's still alive?
Yes. Well, they're starting to think about the father's estate and organizing things for the mother's estate. Now, the mother died in 2015, of course. She was there May 10th, 2015. We have both of these death certificates in the record. That perhaps would be the latest. It is, as the Judge Gildea mentioned, it seems a little unfathomable in a situation like this that you wouldn't, at some point in that period of time, at least have asked your sister, where do we stand on this? And I've never gotten anything in writing on this. And by the way, if they had said that to her, and if this was, which it was not, by the way, but you don't know that at this point, if this was some kind of fraudulent scheme and she had made a misrepresentation to them at that point, then they would have had a tolling of the discovery rule.
Is there what are the rules governing the recording of trust instruments or practices, and where would we find them? In other words, what is it that's ordinarily lodged with the registry? Is the trust instrument itself normally filed with the registry?
Well, I am sure if you went into some of the best practices stuff at MCLE, you would find this. I've been doing this long enough now that I know when I look at a trust or a trust certificate that keeps the beneficiaries offline, it's usually a nominee trust. If it's a trust that's a genuinely a family trust, I mean, then the trust does get recorded. I've seen that numerous times, that if property is to be owned jointly by a trust that's for benefit of the family, the trust itself will be recorded and the beneficiaries will all be identified. But that's for purposes, of course, of future conveyances, to make sure that the title is clean and they can, without having to go to the registry of probate, they can figure out who the beneficiaries are.
So let me see if I understand. So the certificate, you're saying that the certificate that was filed here is all that's normally filed when it's a nominee trust?
And the trust itself. I mean, the
deed was filed here. I don't know if there was a nominee trust filed, a document entitled the Realty Trust. Clearly, no list of beneficiaries was on record.
That's correct.
So what we have in this record is, or at least a reference to a deed from Sullivan to the DEVICO Realty Trust.
Correct. We actually have that deed in the record as well.
And so there's no other trust documents that were ever recorded?
That's my understanding, Judge, yes.
And the certificate that Judge Wolohojian mentions, that doesn't relate to this particular transfer.
I think it may have been, I don't know, Judge, I'm sorry. I don't have it in front of me, and I don't know.
Is it your position that the brothers were, they were in a fiduciary relationship with the sister at any time?
No. In fact, I think I would say that's the ultimate catch-22 of this complaint, is that the wrongful act of my client that is alleged here is that she did not create a trust. They allege that the parents told her to create a trust and she did not. So that's their ultimate catch-22, that she actually just, if there was a promise made to her parents, she breached that promise and took the property herself, that there was never a trust actually created.
And so therefore, because the trust was never created, there was never a fiduciary relationship with the brothers?
That's correct.
There can't be some kind of constructive trust that was created by the oral request from the parents?
Judge, there can be, but it's not. I looked at this very carefully because that was argued by my brother. He argued both the resulting trust and the constructive trust, and you'll see I addressed that. Those are both equitable remedies, and they're imposed in an unjust enrichment situation. And I could find no case in Massachusetts or anywhere else where somebody used those principles of that remedy, that equitable remedy, to say, oh, there was a trust, and therefore she had a duty to report it, and therefore we're going to toll the discovery rule. Those are the trust. I mean, the fact is the trust, the constructive trust, doesn't really even exist until the court creates it in its final judgment.
So let me ask you a different question.
Yes.
Let's just divorce it from, well, let's just assume hypothetically someone alleges that our parents asked our sister to create a trust for the benefit of all of the children, and she didn't do it. What would be the cause of action in your view, a viable cause of action based on those facts? Setting aside statute of limitations or anything, I'm just asking, is that conversion? What is that in your view if it's not breach of fiduciary duty?
Well, it could be a breach of contract to the parents, could be, that would be kind of the most direct breach of contract, or if you could make it out that she had made fraudulent statements to induce them to do it, fraudulent inducement, but that would all be prosecuted by her parents' executors, not by her siblings.
By the estate.
And if that had happened, obviously we wouldn't be here, because particularly if it had happened when the dad died, because we still had the mom available. I mean, the best evidence in this case, obviously, are from the mom and the dad, who, because of the extensive delay here, are no longer around to say what they wanted. And it is, I would respectfully suggest, it's a bad idea to allow the siblings, 13 years later, after their parents passed away, to say, oh yeah, mom liked me best. She really wanted me to have a cut of this.
Okay, but we're gonna have to leave it there, Mr. Ryder.